Alrighty, welcome everyone to our webinar on legal considerations when leveraging digital marketing. My name is Hammy and I'm an associate in LegalVision's commercial and privacy team. I'm joined today by my colleague Lauren, who is a practice leader in LegalVision's commercial and privacy team. Before we begin, a couple of quick housekeeping items. You'll receive a recording of the webinar and the slides in your email, so you don't need to frantically take notes, but of course feel free to do so. You can submit some questions in the chat box and we'll answer them at the end. And at the end, there will be a feedback survey, and we'd really appreciate it if you could take a couple of minutes to answer that for us. Also, all attendees are eligible to receive a free consultation with us to discuss how we can help you with your contracts or any of your legal needs. To request your free consultation, simply provide us with your contact details in the survey that appears at the end of this webinar. So today, we'll be discussing privacy and how you can make sure your business is compliant. We'll start with a discussion about digital marketing in the digital era. We'll then have a discussion around cookie compliance, the advertising code, some privacy pitfalls, and we'll finish off with some Q&A. I'm going to hand over to Lauren, who's going to kick us off with some discussions about direct marketing.
Thank you so much, Hammy, and thank you everyone for attending today. So as Hammy mentioned, I'm going to start off by talking about digital marketing and basically the legal steps you need to take to comply there. Essentially, direct marketing is a form of advertising that involves you directly communicating with your customers or potential customers. Usually that's through mail, so the post, email, or telemarketing. Today, I'm going to focus primarily on email just because that is, I suppose, the most popular form of digital marketing in today's age and basically a necessity in terms of having a thriving business. So email marketing, obviously, it's a good way to make sure that your customers are aware of new products you've got, any discounts you're providing, other goods and services you sell. And it can also be a sort of softer sell or a way to educate your audience on the value of your products and your brand and keep them engaged between purchases with you. In terms of solicited marketing, so that's when someone directly requests for you to send them some sort of marketing. There's no restrictions on that. Of course, you can just send that marketing if they've requested it. However, there are restrictions when someone has not requested you to send them with some marketing. So I guess the starting point that you should always consider is that you need to rely on consent to send direct marketing. So if you're going to send emails that are marketing your brand, you need to have consent unless there is an exception that applies, which I'll run through those key exceptions in a minute. In terms of gaining consent and obtaining that, for it to be valid, it needs to be knowingly and freely given, clear and specific. So this is something that some businesses sort of fall into a bit of a trap here, but essentially an individual has to have a genuine choice over providing consent or not. It can't just be the only option. Individuals must be informed about what they're consenting to. So if you're going to be sending emails, text messages, as well as phone calls, you need to let them know that, and not just that perhaps they're going to receive emails, but then you text them as well. And the consent must be granular and specific. So in that example there, you should be getting consent to send emails as well as text messages, as well as those calls. And lastly, there needs to be some sort of positive action put in place by the customer in order to consent. You can't just sort of say, by looking at this website, you consent. It needs to be a positive action, like checking a box or putting their name in some sort of field. The clearest way, obviously, being that opt-in box, which is what you're probably familiar with seeing. There are a couple of key exceptions to gaining consent, and the first one is known as the soft opt-in. So basically with the soft opt-in, you can send marketing texts or emails if you have obtained the contact details of your customer, of the individual, in the course of a sale or negotiations of sale for a product or service. So essentially, what that means is that if you're selling perhaps t-shirts online and you get someone's email address in the course of them making a purchase from you, this would fall into that soft opt-in. So you've got it in the course of a sale. You need to make sure that if you are going to rely on this, that you're only marketing your own goods and services and things similar to what is that they purchase from you. And lastly, you need to give those individuals an opportunity to opt out at the time of you collecting their personal details. So what this looks like in practice is that on that t-shirt website, when someone's making a purchase, right at the end when they're checking out, you've got an opt-out box which says something like, please do not send me ads and offers about our or your business, for example. So that opt-in option is really commonly used by a lot of businesses. You just need to make sure that you're collecting it in the course of sale and you give that really clear opt-out option. In all of the marketing materials you send, you need to identify who you are, and you also need to provide users with a really easy way to unsubscribe. And of course, you need to action that request. The other key exception that might apply to some of your businesses is called the corporate subscriber exception. So that's where you're sending emails to limited companies. It doesn't apply to sole traders, but when you're sending an email to an LTD company, you don't need to get that consent. The only requirement is that you identify yourselves, and also would recommend including that unsubscribe functionality. Just in terms of a really large business that we saw get a fine earlier this year was HelloFresh. And I think that's probably a good warning for a lot of businesses. They were fined £140,000 by the ICO for sending 80 million spam emails and text messages. Essentially what they did is they had an opt-in statement that mentioned communications by email, but it didn't reference receiving text messages. And the opt-in box was included as part of an age confirmation that asked people to confirm they were over 18 so they could receive free sample gifts. This basically unfairly incentivized people to opt in because they were trying to receive the free sample gifts, not necessarily wanting to opt in for email marketing. Wasn't clear how people could opt out. They weren't given information about how their personal data would be used. So essentially, they were given £140,000 fine, and it's a good reminder that the ICO are cracking down on this sort of direct marketing compliance there. What I'll do now is I'll get Hammy to have a bit of a chat through cookies and using them on your website and how you can do so in a compliant manner.
Thanks, Lauren. So cookies are text files placed on a device's browser to store an individual's preferences. This could be their marketing preferences, or it could be used to remember what items are in someone's cart, for example. They're used by many websites and they can do a number of things. They can also count the number of people that are looking at a website and just track where people have visited from. They can also be used for advertising. This is why sometimes when you visit an online store, you then get targeted ads about whatever product that online store was selling on Instagram. Where you use cookies, you must tell individuals that you use cookies, explain what the cookies are doing and why, and get the individual's consent to store any non-essential cookie on their device. This is why you will often see cookie pop-ups when you visit a website. The business is telling you about the cookies they use and they're seeking your consent to do so. Now, just going back to what I said quickly about non-essential cookies. So a non-essential cookie is any cookie that isn't necessarily required for the website to actually operate. An example of this would be any sort of advertising or marketing cookies. For example, a cookie that remembers what items an individual has added to their cart on an e-commerce platform, that's probably considered an essential cookie because it's necessary for the website to be able to operate. However, advertising cookies aren't necessary for the website to operate, and therefore they're considered non-essential. To be valid, consent must be freely given, specific and informed. It must involve some form of unambiguous positive action, like ticking a box or clicking a link, and the person must fully understand that they are giving you consent and what they are giving you consent for. You cannot show consent if you only provide information about cookies as part of a privacy policy that is hard to find, difficult to understand, or rarely read. Similarly, you cannot set non-essential cookies on your website's homepage before the user has consented to them. Pre-ticked boxes or pre-checked sliders are not adequate consent. So on your cookie pop-up, it needs to be, individuals need to have a genuine option as to whether they hit yes or no, as to whether they accept or reject the use of any non-essential cookies. As part of your cookie pop-up, you should provide detailed information about what cookies you use, what they're doing, and why you use them. This information can be displayed within the cookie pop-up itself or on a banner, or you might even link to a separate cookie policy or your privacy notice if cookies are covered in that privacy notice. It's important to get your cookie consent practices correct from day one, as the fines for non-compliance are significant. We're talking about up to about £500,000 per infringement. The EU has similar laws in place, and if their enforcement actions are anything to go by, regulators aren't afraid to hit businesses with large fines where the business hasn't complied. In the last 4 years, European regulators have issued significant fines to some very well-known brands, including a 60 million euro fine to Microsoft, a 162 million euro fine to Google, and a 65 billion euro fine to Facebook for making it too difficult for individuals to opt out of or reject cookies on their respective websites. Each of these businesses allowed individuals to accept cookies with just one click, whereas rejecting cookies required multiple clicks. The complexity of trying to reject cookies discouraged users from refusing cookies and violated their freedom of consent, and therefore the regulators were of the view that this wasn't valid and specific consent that was freely given for the purposes of the GDPR. Now, one of the other important key considerations is the advertising code. So I'm going to hand over to Lauren again, who's going to talk through some of the things that you should be thinking about there.
Thank you, Hammy. Yeah, I think that's a good point on cookies. I've certainly seen a lot of websites these days where the option is very easy to accept cookies and the option to reject them is much, much harder to find. They use different colors, different language to really sort of disincentivize you from selecting that you want to reject those cookies. So yes, in terms of the advertising code, essentially in the UK, this is that we've got two codes that lay down the rules for businesses to follow, or advertisers, agencies, etc., when marketing your business. So there's two codes. We've got the non-broadcast advertising and direct and promotional marketing code. So this is the CAT code. Essentially, this is the rule book for non-broadcast marketing. So if you're sending email communications, if you are doing promotions on your website itself, this is all in the CAT code. We also have the BCAT code, which applies to broadcast advertising. So that's things like TV ads, radio ads. So perhaps something your business might be doing less of, or you might have a marketing agency helping you, but both of these apply. Essentially, they go into detail on subjects such as misleading advertising, advertising to children, making any sorts of claims. So this includes in relation to the environment or any nutritional claims. And if you're advertising products that might be seen as a bit more sensitive, such as gambling, lotteries, alcohol, tobacco, e-cigarettes, you're going to find that there are specific sections on your products as well and when you're advertising them. The codes are pretty simple, and I'd certainly recommend taking a read through them, particularly if there's some relevant sections to your business. Some of the sections will apply to everyone though, and one of those key sections is that marketing communications must not materially mislead consumers or be likely to do so. So this means that when you're engaging in any sort of marketing or on your website, you mustn't omit any material information. So you don't want to be hiding delivery fees, for example, or if your prices don't include taxes, this would be considered to mislead. Anything that essentially is presenting information as unclear, ambiguous, this would be misleading. We've recently had a string of well-known companies in the energy space that have received some fines from the Advertising Standards Authority for omitting material information. So essentially, they were promoting green offers, plans such as renewable energy and net zero goals without mentioning any of their also other polluting operations. The ruling sort of pointed out that the polluting operations and products still dominated those businesses or what they were doing, and these sort of one-off products were not really enough to outweigh that in terms of marketing, so it was considered to mislead people. The last thing we'll go through today before we get into questions, so if you've got questions, please submit them through. We always love going through these because we can make sure that we answer anything that's on your mind. Hammy's going to run through privacy pitfalls.
So, privacy is where we see a number of businesses' regulatory compliance go sideways. Um, Every business operating in the UK is required to comply with the General Data Protection Regulation, otherwise known as the GDPR, which sets out the rights individuals have in respect of their personal data and how a business must treat any such personal data they receive access to. One of the key themes of the GDPR is transparency, that individuals have a right to know and understand which of their personal data is being collected by a business, what purposes it's being used for, and how it will be stored and handled. To that extent, every business should have a privacy policy. This should be a holistic document that covers all personal data that you collect across the entire business and not just personal data that you collect on your website. The GDPR sets out exactly what must be included in a privacy policy, and this privacy policy should be easily and freely available to individuals, such as on a page on your website. You should also provide this to individuals whenever you collect personal data from them, for example, on a Contact Us page on your website. Another common pitfall that a lot of businesses face is collecting too much personal data that they do not necessarily need. You might get excited by the thought of collecting every single piece of information you can about your customers so that you can tailor any marketing towards them or make business plans based on their preferences, or just in case that information may come in handy later down the track. However, this can be a dangerous hole to fall down, as a business must have a lawful basis for processing each piece of personal data that it collects, and any information collected must be necessary for achieving a specific purpose. If you could reasonably achieve the same purpose without processing personal data, you won't have a lawful basis for collecting that personal data. Therefore, by collecting unnecessary information, you're leaving yourself open to a finding that you did not have a lawful basis to process the personal data that you've collected. It's also important that you're generally familiar with the privacy legislation and how it applies to your business. Individuals have a number of rights under the GDPR, such as the right to access, the right to rectification, and the right to erasure, amongst others. If you're not familiar with the law, you won't know how to respond if an individual makes a request to exercise one of their rights. Typically, there are time frames within which a business must respond to such a request, and being familiar with your obligations under the GDPR will put you in the best place to respond. It will also mean that you won't be flustered when you receive such a response. So, we've recently encountered a situation where um, a client received a a subject access request, so a request from an individual requesting access to their personal data. However, this business did not respond in the allocated 30 days. And when the individual sent a follow-up, the business didn't respond again. So now the business found themselves in a position where the individual is filing a claim for compensation because they have failed to respond to the individual's requests. So these are issues that can be very easily avoided if you're aware of what your obligations are under the GDPR. The ICO recently issued TikTok with a fine of £12.7 million for a number of failures in respect of compliance with the GDPR. Some of the breaches listed on the infringement notice were a failure to provide individuals with the information contained in Article 13 of the GDPR, which sets out what must be included in a privacy policy, a failure to provide information in a concise, transparent, intelligible, and easily accessible form. And then finally, failing to ensure that personal data was processed lawfully, fairly, and in a transparent manner. So as we could see, all of the issues in that infringement notice lead back to the key theme of transparency. TikTok failed to be transparent with their users about how their personal data would be handled, and therefore they were slapped with a pretty large fine. In February this year, the ICO issued a reprimand to the Devon and Cornwall Police Force for failing to respond to subject access requests in the legislated timeframe, so not even public sector authorities are safe from enforcement action taken by the ICO. The ICO has a lot of website, has a lot of useful information and tools in compliance with the GDPR, and of course, you should definitely get legal advice specific to your circumstances to make sure that you understand exactly what is needed from you. So that concludes the main part of our webinar. We have a fact sheet on GDPR essentials, which you might find useful, and you can download by scanning the QR code on your screen.
You can also, I think in the handout panel, you can probably download that. We've also got an upcoming event that may be of interest to you. So that is capital raising essentials for startups. So if you're looking to raise capital, you're looking to get some investment in your business in exchange for equity shares, then this is probably the event for you. That will be on Tuesday, the 16th of April at 11 a.m. And you can register on our website using the link there. So we'll run through questions in a minute. If you could submit them now while you've got a few minutes, that would be great. And we'll take a minute to tell you a little bit more about LegalVision's membership. So essentially, by becoming a LegalVision member, your business will get access to unlimited access to our full team of specialist lawyers for all of your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team will be able to assist you with unlimited document drafting, reviews of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration, and much more. As a LegalVision member, you won't have to worry about the costs of lawyers ever again. Think of it as having your own in-house counsel will take care of the business as usual legal work so you can focus on running your business. To learn more about how membership can help you, you can request a free consultation when the survey appears at the end of this webinar. So what we'll do now is we'll run through some of the questions that have been provided. And I think we also had a couple that were provided earlier before we started the webinar. So the first one, Hammy, I will let you take this. It says, does the UK have any UK legislation that replaces the GDPR post-Brexit?
Thanks, Lauren. So, in the UK, privacy is governed by the Data Privacy Act of 2018. This includes the text of the EU GDPR, which has been retained and is now known as the UK GDPR. So, essentially, the GDPR still applies in the UK, even post Brexit. They are currently still exactly the same. There is also a current government bill that is not yet law called the Data Protection and Digital Information Bill. This may come into force later this year, however, it has not yet been finalised. So that's something we're keeping an eye on, and we'll keep our clients updated on that one.
Thank you, Hammy. We've also got another one that perhaps you can answer as well, which is where do we need to put our privacy policy?
Yeah, sure. So every business should have a privacy policy like we've already gone through with this webinar. It should be displayed on your website if you have one, in your store if you have a physical presence, and whenever you collect personal data from an individual. So for example, if you have a contact us form on your website, you should make reference to your privacy policy in that contact us form. If you have a physical presence and individuals fill in forms in your store, for example, you're a hairdresser or a laser clinics provider, and you have individuals that come in and sign waivers or forms, you should also attach a copy of your privacy policy to any forms that are completed by individuals.
Mm-hmm. The next question we've got here is what should I pay attention to avoid legal issues with regard to copyright, privacy, and not be blacklisted as spam? Perhaps what we can do is let's break this down into sort of three sections, the copyright part, privacy, and being blacklisted, which of course is, if you're putting a lot of energy and effort into marketing, you don't really want to fall into any of these three traps here. In essence, copyright protects your work. It stops other people from using it without your permission. And in the UK, copyright is created automatically. So this means that if you create something, for example, you design a logo, you write a blog post, perhaps the contents of an email, you're going to be the owner of that unless you've got some sort of contract that assigns ownership to someone else. So essentially, to avoid infringing a third party's copyright, you need to make sure that you and your staff do not copy, steal, base any of your work off someone else's or send on someone else's work. You should be really clear with your staff on this, that that's not acceptable behaviour in their role, that they need to make sure everything that they produce is their own work and not copied from anyone else. That goes for contractors as well. And if you've got contracts in place with anyone, so you're working with contractors or you've got maybe a marketing agency or someone working for you, you should also have some promises in those contracts from them that one, they're not going to copy anyone else's work, and two, that they will assign ownership of any content they create to you. So I think the key message here is making sure in your contracts that you own work that's been produced that you're going to use, and secondly, you're not copying anyone else's work in anything, whether that's on your website or in your emails. Hamid, do you want to touch on here? They also asked
Yeah.
about tips to avoid legal issues with regards to privacy and not be blacklisted as spam.
Yeah, so like we've just discussed, you will need to familiarize yourself with the GDPR. We probably don't have enough time to go into this in detail today, but just making sure you know exactly what your obligations are as a business, as well as what rights individuals have and what they may ask of you. We have a webinar on YouTube that focuses just on the GDPR, which could be useful, and the ICO website also has some really useful information. And of course, the best thing to do is to seek legal advice tailored directly to your business based on what it is that you're trying to do. The second part of that, I guess, is on how not to be blacklisted as spam. This is not so much a legal question, so perhaps any developers on this webinar may know more than us. But some of the types of things that you can include, that you can do, include create high quality, engaging content, include an unsubscribe link that's easily accessible, ensure your contact list is up to date and clean it on a regular basis, avoid spam words, get consent before sending emails, and consider a double opt-in system. Don't purchase email lists because some purchased email lists can contain spam traps, and remove any email addresses with typos from your email list.
Okay, I think that's some good tips there, Hammy. Certainly, I think getting sort of tailored advice for your business is a good idea. And also, yeah, a lot of businesses will use third-party software like MailChimp, Klaviyo, etc., to help them manage the emails they're sending out, help them manage those unsubscribe links, the consent there as well. We've had another question come through that says, I wonder how emails should be treated which contain personal data of suppliers, job candidates, clients, etc. Emails are very useful, including in cases of future disputes, so must they necessarily be deleted after a specified time frame? This is a great question, and I presume what they're getting at is perhaps the right to deletion. Which individuals have under the GDPR. So I guess as a starting point in terms of when you're sending any emails that have personal data in them, you need to have a think about whether you've got a lawful basis to rely on in order to send that personal data. So under the GDPR, if you're doing anything with personal data, there's 6 different lawful bases. You need to make sure that one of them applies to what it is you're doing. So you might need to send the personal data of a job candidate, if you're a recruitment company, for example, to the company that is curious or interested in hiring that person. You might be able to rely on performance of a contract because you necessarily need to share that data in order to provide services to that end candidate. Perhaps they've consented, so you might be able to rely on consent. So there's different sort of lawful bases, which we won't go through today, but you need to make sure you've got a lawful basis there, and then you need to treat it in accordance with the GDPR. So you need to make sure you're only you're putting in place technological and organizational measures that are, I guess, satisfactory in terms of what you're doing to protect that data. In terms of keeping information, we've got in the GDPR, it sets out some principles that sort of govern the GDPR and how you should handle personal data. So some of that, as Hammy mentioned before, is around transparency. We've also got different principles around storage limitation and data minimization. So only collecting what we need to collect and only storing it for so long as you need it. Now, of course, there's always exceptions with these things. So I think particularly when you've got contracts in place with clients, if someone made a request for a deletion, you need to check through if there is any exception there. And a lot of the time you might want to keep it to and the reason being you're relying on a legal obligation, being that when you've got a contract in place with someone, typically after that contract ends, if either party wants to make a claim against the other party, they can do so within the 6-year period. So probably you'd want to be keeping that information, at least during that period of time, so that if any sort of claim is made, you've got that evidence there. Certainly, basically, when you get through requests for deletion, it's always a case-by-case situation, not necessarily some sort of blanket test, but that's always going to be different. So if you've got people that are customers asking you to delete things, as opposed to perhaps someone that just signed up to your mailing list, has never been a customer, and now wants you to delete their email address, that's obviously quite a different scenario.
Just on that point, Lauren, I think it's also important to note that the right of erasure doesn't apply in all circumstances. So there are only certain specific circumstances in which the right to erasure or the right to deletion will apply. So if you do get a request for deletion, seek some legal advice about the specific circumstances and find out if you do actually need to comply with that.
I think, yeah, that's a great idea. Hammy, we also had a question that came through about Creative Commons, which the question is, how can I use materials covered by Creative Commons share-alike license?
Sure. So Creative Commons is a licensing system that gives everyone from individual creators to large institutions a standardized way to grant the public permission to use their creative work under copyright law. There are different types of Creative Commons licenses, and they only apply if the author or the only owner of the creative piece actually says that they apply. So you can't just take any content off the internet and say you are using it under a Creative Commons license unless the author of that content has specifically stated that a Creative Commons license applies. Now, one condition in two of the current licenses is a share-alike condition. That is, that it requires any copies or adaptations of the work to be released under the same license as the original. So if you are using any work that is licensed under a license that has a share-alike condition, you will need to make sure that any work you produce out of that is also shared under the exact same license.
Excellent. Now, another question that's come through is on, are you allowed to use publicly available information on individuals to contact them initially? So contact details for an individual found on a website. The ICO website doesn't seem so clear on this. I guess this comes down to what websites that you're seeing there, and what the contact details are, who they're for, and also if there's any other information on that website. So if you're looking around online, you want to sell to another business, you see some people's email addresses on that business's website, there won't be issues there. Presumably they are corporates, and so one, you fall into that corporate subscriber exception, but two, if businesses have their email addresses on the website, presumably they also want people to contact them. If you've got websites with individuals' email addresses on them, I'm not too sure in what situations that would arise. Certainly if you're sort of buying email addresses, then you'd need to have a good think about whether those consent was satisfied and whether or not you can actually email those people. I think the most common situation where you might see an individual's email address is probably on LinkedIn. Or you might not necessarily see their email address, but they might, you can send them a message through LinkedIn. So there, I guess, essentially by having an account, they're probably making it clear that they're happy to be contacted, but you need to make sure you're contacting them for things that are relevant to what their profile is. So if I'm got my profile there as a lawyer at LegalVision, a commercial law firm, and then you're trying to advertise your, I don't know, funeral services or something completely irrelevant to my job and completely irrelevant to my profile, that's probably not appropriate. But if you are offering me a job or advertising something relevant to my business, trying to network with me, that would be much more appropriate. I'm not sure if I've answered that question properly. If you've got more information there, do let us know, or feel free to book in a free strategy consultation with us and we can go through that in a bit more detail. But in essence, if there's information publicly on the internet, if it's a business, you can go ahead under the corporate subscriber exception. If it's an individual, you need to look at the context there of, are they sort of asking people to email them and contact them for certain reasons, or are you spamming them, I guess? Or is it a case that you've purchased that mailing list from someone else, in which case you need to make sure that whoever sold it to you did have that consent?
And also just have a look at, wherever you are finding these email addresses, have a look at what other content is available there. So, for example, if you're finding an email address on a website, does the website say no spam emails or no marketing emails? And if it expressly sets that out, and make sure you're following that. Don't just ignore that bit because you can rely on a corporate subscriber exception, for example.
Exactly, that's right. We've had another question come through around using visitor tracking on a website. So does this need to be specifically mentioned in the privacy policy? We only receive information on the company, not individual details. Hammy, did you want to take this one?
Yeah, so again, going back to what we said earlier, you need consent in order to use any sort of cookies. So if you are using cookies to track the visitors that are visiting your website, you do need consent from the individual, because presumably it will be an individual that is using your website and not the company itself.
Very good, very good. We've also had a question coming through asking what our privacy policy needs to include in general. Hammy, do you have some thoughts on this one?
Yeah, so the GDPR is actually very clear on exactly what needs to be included in your privacy policy. It's all set out in Article 13. At a high level, your privacy policy should set out what personal data you collect, what you intend on using that personal data for, and what lawful basis you rely on to do so. It should also set out who you may transfer the personal data to, so for example, who your processors are, and what rights individuals have in respect of their data, such as their right to access or rectification and their right to make a complaint to the regulator.
Very good. I think we've had a couple of quite specific questions come through, some more on Creative Commons, etc. If you've got specific questions around your business, what I'd suggest there is getting some specific legal advice on that, whether that's through us if you're a member or booking in a strategy consultation with us. We can answer those questions directly that might apply to your business there. So I think that's all we've got time for today. After the webinar ends, a survey is going to pop up, and we'd really appreciate it if you did take the time to complete that 30-second survey. If you want to receive a complimentary legal consultation to discuss how we can help you with your business, then you can leave your details there. Thank you everyone so much for joining us today.
Thanks, everyone.